А, СТЕМ каналу Лимба Инглеза. СТЕМ каналу Лимба Инглеза.
Нет, надо. Да, кстати, Вика еще
СТЕМ канал Лимба Инглеза. Dear colleagues, please take your seat. We shall start. The representatives of authorities who are connected via Zoom. So we can start now. Good afternoon, and I'd like to thank the participants who continue their participation here in this event. So it is the 2022 edition of the Index of Transparency of Access to Public Information to Public Authorities. A number of logistical aspects. The event is organized in hybrid mode. Currently, they are connected over Zoom, over 60 representatives of authorities who requested to participate in this event. There is simultaneous interpretation provided. Remark for the participants who are going to use interpretation via Zoom. So in Zoom, Romanian language, it is called French. So the button is French for Romanian language. It is broadcasted via Realitate Media. And this being said, so those who are connected via Zoom, if there are any questions and you'd like to intervene, colleague Alessa is following all comments that appear on Zoom platform. It is quite a usual or maybe less usual composition of participants today. So every time we had such events on access to information and the way represents public authorities according to the agenda there was planned to have a representative of the Ministry of Justice, because Ministry of Justice is now working on developing a new law, updated law on access to information. Also a representative of representative of the Parliamentary Committee on Media, who for last years, with the support of the civil society, they're trying to adopt amendments on access to information, which are still being developed. Minister of Justice did not accept our invitation. The state is saying that they are all busy, and representative of the parliament, they said that they had some other events planned for this afternoon. We decided to invite other journalists, Mariana Ratza Well, certainly you're not going to replace representative authorities, but you will have the opportunity to participate in this panel and continue the discussion that we had in the morning. So I'd like to give the floor to Chipoi, the Director of Internews Moldova, who will moderate this session. Thank you, Tatiana. We're very happy with the cooperation that we have with Freedom House Moldova, and we are very, very thankful for supporting this forum. Besides the thanks, I also there's some deception because I do not see representatives of the authorities. I had a quite intense session with representatives of authorities in the morning, in the first part of the day. I also wanted to have representative authorities present during the afternoon session. We have the report printed. It's an index, access to information index, and I recommend you to see the report, particularly that it is the second report, and you can make a comparison. So I'd like to ask Mr. Darius Michel, to author the report, to tell us what were the findings this year and what was the methodology used and some comparison with last year.
Thank you very much for giving us the opportunity to present the second edition of our study, of our review, that combines analysis of the quality of Moldovan legislation on access to public information with insight into practice. I think it is quite innovative approach, even looking at from broader European perspective. So there are some international rankings of the quality of legislation on access to public information, but legislation is only the first step always. What really counts is how the freedom of information, how the right of access to information is guaranteed in practice. So this kind of rankings that concentrate only on the legislation could be sometimes very misleading. I remember that the most comprehensive, biggest ranking of the quality of legislation on access to public information, the so-called right to know index or rating, demonstrated that the best quality law in the world on access to public information for many years was in Afghanistan. But it didn't really mean, especially now, it doesn't mean that this is the most transparent country in the world in terms of what public authorities share with people. For that, we need to have a look also in practice, not only in the law. That's why we created kind of a methodology that covers both legislation and practice, giving also priority or giving more weight to how the law on access to public information is implemented in practice. This index, Freedom of Information Index, is composed of 3 elements. First, assessment of the legislation. Secondly, assessment of so-called proactive transparency. Proactive transparency is at the heart of effective implementation of the right to information. Proactive transparency is about quality and quantity of information that public authorities share without being requested, share on their websites mainly, of course also through any other means of communication with the citizens. And the third element is performance of public authorities in processing public information requests. So it's about timeliness, about respecting deadlines for response, but also and mainly about to what extent the authorities share with citizens what is public information, what should be disclosed by public institutions. Combining these three elements, we conducted our assessment, and I will present on the next slides in details the results of the assessment. But the overall scoring did not change much since last year. So there was no major progress, luckily no major regress also. But the situation is stable, which doesn't mean it's good. It's really far from being good. It's really far from conclusion that Moldovan public authorities respect the right to public information. The problem, as you can see, starts with the quality of legislation, but this the main issue is, of course, the performance of public authorities in practice. So it is clear that we should start with new legislative framework, but then focus on making sure it's implemented properly. In terms of the quality of legislation, we measured this referring to some basic international standards, including Tromsø Convention, that is ratified by Moldova, that is part of the Moldovan legal system, but also considering other, usually more ambitious standards, because Tromsø Convention, while being the first international treaty dedicated specifically to right to information, it is also a document that promotes rather, let's say, modest standard, minimum standard of transparency. There are many standards that goes further, for example, standards developed by international NGOs like Article 19, but also the standard that I was pleased to contribute to development, standard of OECD Sigma program, and principles of public administration developed by this organization. We managed to set more ambitious standards relating to quality of legislation, quality of laws on access to public information. And based on this, we developed methodology that's enabled us to assess the quality of current law on access to information in Moldova and other laws that are relevant, for example, administrative code. Based on this, we can conclude that the current law on access to information in Moldova was relatively modern, relatively good at the time of its adoption. But 2 decades later, it became obsolete. It's a law that it no longer follows the trends, the standards of transparency of public institutions that are widely internationally recognized and accepted. The main problem is that this law practically completely ignores the issue of proactive transparency. So what should be at the heart of the system, what should be the essential element? So public authorities sharing voluntarily information on the websites and through other means, this is practically ignored by this law. It's not only about lack of extensive catalog of information to be published on the website. It's also about lack of monitoring, lack of compliance control. Then problems exist also with regard to the other elements, especially to processing public information requests. So there are unclear rules on fees. There is ineffective mechanism of appeal enforcement. There are some conflicts resolved to some extent by Supreme Court of Justice, but not fully, with the new administrative code. So all in all, the quality of legislation on access to public information is poor. It does not secure effective right to information. It creates multitude of problems in practice. Second element, proactive transparency based on the review of the website of public institutions. This job was also based on a unified methodology where we reviewed the website of public institutions in order to check whether you can find there information, some basic information that are required by international standards. What is the main problem is availability of data relating to financial, personnel, organizational issues. So the overall quality and quantity of information on the website of public institution is poor, is low. Similar problems with access to information upon request. Here we distributed sample requests to public institutions and checked the quality of responses received. What became clear to us that there is serious problems among public authorities, especially about understanding what is the relation between a right to information, between transparency requirements and standards relating to personal data protection or confidentiality of information. So, for example, the major problem, the most common problem was refusal to provide us with information about the salaries of persons at managerial positions in public authorities. It was often a problem that public authorities responded that they cannot share this information because of principle of confidentiality of salaries under labor code or because of protection of personal data. So authorities completely ignored the nature of this information as public information, but they looked only on the small part of the picture, focusing only on Labor Code, on Personal Data Protection Act, instead of conducting a whole legal analysis that would lead them to the conclusion that this is okay, this is personal data, but it is subject to disclosure under law on access to public information. Even the current law enables this. We don't have to wait for the new law to release this kind of data, but still public authorities do not understand this basic legal issue. What to do following this review? What should be the way forward? How to start changes that are clearly necessary? Of course, it's obvious from my perspective that we have to start with the new law on access to information. And I'm here presenting this report, but I also work for the EU Moldova Association project where I support developing drafting of the new law on access to public information. It's indeed, as was mentioned already, it's a pity that we do not have representatives of Ministry of Justice, of Parliament today, because we are entering now the very critical, crucial phase of work on the new law. And as far as I know, we are approaching the phase of open public consultation about the draft. And it's very important that as you are present here, you also have the opportunity to contribute, to share with your experience, with the government, with the Ministry of Justice, to make sure that this law significantly improves situation, or at least will be the first important step on the way towards improvement. I think during the panel discussion we will maybe refer to some detailed elements of the new law and potential shortcomings of this draft, but also what it can improve. So for now, let me just thank you for your attention, and I will now give the floor to my colleague Stella, who did a tremendous job on collecting data, on assessment of websites of public institutions, on processing requests for public information, and she will provide you with more in-depth insight to some results of our review. Thank you very much for your attention, and of course we will be glad to receive questions during the panel discussion.
Întrebarea se poate după a doua parte, pentru că coautarea. Doamna Stella Pavlov este coautarea raportului. Să terminăm cu prezentarea raportului și acum, imediat după asta. Imediat completează și Stella Pavlov, care este coautarea, cum am zis eu, a raportului. Aș vrea să termine cu prezentarea lui și apoi să trecem la întrebări cu plăcere. Mersi și poftim, Stella.
Please.
Bună ziua tuturor!
Good afternoon.
Nu știu dacă se vede, da? Eu o să mă refer mai mult la partea practică și o să încep cu pilonul 2, ce ține de transparența proactivă. Deci, transparența proactivă, în principiu, stă la baza asigurării eficiente a dreptului la informare. Aceasta reprezintă, de fapt, partajarea și actualizarea dreptului informațiilor publice pe paginile web, ale instituțiilor publice sau prin intermediul portalurilor informaționale ale Guvernului, fără a fi necesare solicitări sau cereri de informații din partea publicului larg. Deși cadrul legislativ ar trebui să prevadă o listă exhaustivă a informațiilor care trebuie publicate în mod proactiv, lipsa acestea sau numărul limitat de informații incluse în ea nu trebuie să descurajeze instituțiile publice să publice în mod voluntar cât mai multe informații posibile. Analiza practicilor în acest sens s-a bazat pe studierea paginilor web ale instituțiilor publice din perspectiva disponibilității informațiilor de bază despre cadrul lor organizațional, normativ, financiar, precum și a informațiilor despre activitățile și inițiativele lor. Eșantionul care Deci, în scopul acestei analize, noi am identificat 58 de instituții publice de la toate nivelele administrației de stat și 15 întreprinderi de stat și societăți pe acțiuni în care statul are o anumită cotă parte. Din cele 58 de instituții, s-au dus la pilonul 3. Nu mai Deci, din cele 58 de instituții, noi am analizat paginile web a 12 ministere, 12 instituții din subordinea ministerilor, 4 instituții din subordinea guvernului, 10 autorități autonome, 5 organe centrale care nu fac parte din administrația guvernamentală și 15 consilii raionale. Aici avem listate, nu o să le dau citire toate ministerele, cele 12 ministere, instituțiile din subordinea ministerilor. De asemenea, le aveți aici pe ecran. Instituțiile publice din subordinea guvernului au fost selectate, deci Agenția pentru Guvernare Electronică, Agenția Servicii Publice, Agenția Națională Antidoping și Serviciul Tehnologiei Informației și Securitate Cibernetică. Din autoritățile autonome am selectat de asemenea doar câteva. Și 5 organele administrației publice centrale, pentru care Parlamentul, Președinția, Curtea de Conturi, Banca Națională a Moldovei, Procuratura Generală și 15 consilii raionale, comparativ cu anul trecut. Deci anul trecut noi am analizat doar 10 consilii raionale, anul acesta am extins eșantionul cu încă 5. Categoriile de informații care au fost verificate, deci referitor la aceste categorii de informații analizate de pe paginile web ale instituțiilor publice, trebuie să menționez că nu există o listă universală a tipurilor de informații care trebuie publicate în mod proactiv. Totuși, la elaborarea criteriilor pentru analiza paginilor, atât în anul 2021, cât și anul acesta, s-a ținut cont de standardele de transparență proactivă stabilite de principiile administrației publice ale OECD Sigma și ale Băncii Mondiale pentru paginile web ale acestora. Pe slide vedeți categoriile de informații care au fost selectate și anume ne referim la organigrama instituțiilor, bugetul sau planul financiar pentru anul 2022, raportul financiar pentru anul 2021, cadrul normativ care reglementează activitatea instituțiilor, funcțiile sau serviciile care sunt oferite cetățenilor, registrul
register of goods managed and the property were managed by the relevant institution, contact information, including contact information for complaints, petitions, information about vacancies and procedures for employment that were used in 2021 and how in 2022, information about contests for public procurement, as well as information about registers and databases managed by the public institutions. The most interesting was to verify information about salaries of managers and members of administration structures of the institutions and the managers of divisions, structural divisions of those institutions. Thus, taking into consideration all these standards, we came to the following conclusion. In general, the results of the analysis of web pages of the 58 public institutions from various levels of public administration have shown reduced a limited level of proactive transparency. So it was 41% in 2021 compared to 41% in 2021. This result shows a slight decrease The phenomenon, slight decrease phenomena can be explained to some extent by changes to the sample, particularly the increase of the number of district councils that were analyzed from 10 to 15. Thus, we came to the conclusion that on web pages of public institutions are accessible to a large extent only organizational data. So data referring to organigram, legal organization structure, and legal framework. And also it could be observed that most institutions inform proactively about opportunities for employment. Nevertheless, the limited availability of financial data, particularly information about budget, financial reports, public procurements, and information about salaries of managers became quite concerning. So those gaps, those drawbacks are only to a small extent compensated by transparency and governmental transparency mechanisms, such as the public procurement portal mTender, and a web page of National Integrity Agency that contains information, contains declarations of property and interest of public servants. So I came to the conclusion that none of the public institution has published on its web page all the information that was analyzed in the methodology. Only eight institutions accumulated over 50% of the maximum score. And this is the Ministry of Justice, Parliament, Ministry of Health, Ministry of Finance, District Council, Cahul, Orhei, and Strashey, and the Customs Service. The large number of institutions, both at central and local levels, they do not respect, large number of those institutions do not respect essential obligations for proactive transparency, showing a modest transparency from the point of view of proactive transparency. Referring to Ministry of Culture, Indian District Council, Anti-Doping Agency, Service for Prevention and Preventing Money Laundering, and General Prosecutor's Office. As a conclusion, so our conclusion is that progress was not registered in respect of proactive transparency compared to 2021, evaluation made in 2021. Availability of essential data of organizational, financial, and personnel nature remains a challenge. Referring to pillar number 3, access to information upon request. In order to evaluate the openness of public institutions to requests for information, so they were prepared a number of requests, standardized requests of information that focused on information that is considered public, information of public interest. So requests of information were sent on behalf of the organization Lawyers for Human Rights, an organization that is undertaking significant efforts during a number of years, including strategic litigation in order to ensure the right to access to information. In the sample, there were those 58 public institutions, the web page of whose web pages were evaluated, as well as 15 state companies, state enterprises, and joint stock companies where the state has share. Standardized requests of information, public interest were submitted to 58 authorities, institutions. There were 3 questions. So there was a request to present the information about salaries of managers of public institutions, and including monthly salary, also various bonuses, annual bonuses, and the single-time bonuses. Annual bonus and single-time bonuses. Also information about procurement contracts for goods, services, and a small amount goods and services, and also subsidies and grants provided to legal entities in the year 2021, 2022, indicating the beneficial legal basis, legal status, and date when that grant was or subsidy was signed or granted. Regarding the 15 state enterprises and joint stock companies, there was prepared a standardized request of information containing only 2 questions. First was list of contracts of procurement contracts signed in the year 2022, and information regarding the salaries for each member of the administration council, audit commission and the administrator, internal audit commission and the administrator of the institution. So following, after receiving the answers to or replies to those requests of information, we came to the conclusion that all institutions that were included in the sample obtained a minimum score, 45%, so a slight improvement compared to the result of the measurement that was carried out in 2021. So 2021 it was 41%. State enterprises, there was a smaller smaller score, only 40%. Public institutions had a percentage of 46% out, maximum score. The most information that was provided was regarding subsidies, grants, and donations provided to legal entities. And I have to mention that most institutions, the answer was that they did not provide any grants, donations, or subsidies, which actually increased the score. Most public institutions provided information about contracts for procurement, small value procurements, and in most cases it was problematic to obtain information about the salaries of managers of the institutions, public institutions. Here is a rating of institutions that show the high level of transparency, that have provided all or most of the requested information. Ministry of Economy, Ministry of Infrastructure and Regional Development, Competition Council, Audiovisual Council, Presidency of Republic of Moldova, Orhei District Council, Soroca District Council, State Enterprise, International Airport Chisinau, State Enterprise, Mold-Atza, State Enterprise, State Road Administrations, Joint Stock Company Moldova Film, State Enterprise Poșta Moldovei, and State Enterprise Mirești Mici. Compared to last year, some of the state enterprises have responded to our request of information. They were more open, more transparent. We have institutions that have completely ignored our requests of information, and which did not reply to our request of information. Ministry of Internal Affairs, State Tax Service, Inspection for Environmental Protection, Court of Accounts, National Bank, Cahul District Council, Ialoveni District Council, State Enterprise for operation for management of buildings, Rural Project, Urban Project, Metalferos, Tracoms, Joint Stock Companies. Referring to different approaches of suppliers of information, following the requests of information that we have sent them. I will present only some, I will give only some examples in comparison. So, speaking of the information requested about salaries, some revenues, we have an answer from the Agency for Electronic Governance indicating that the declaration of property and the interest of the director of the agency and deputy director of the agency, which include information about revenues obtained from salaries, can be visualized on the webpage of National Integrity Agency. They also indicate that additional payments, additional like bonuses that was provided to the director can be provided when the limits of the salary fund planned in strict compliance with the legislation and regulation adopted through the decision of the council or institution. And then the forms and conditions for salaries and the amount of the salaries within the agency is established through individual negotiation between the employer and the employee, and is established in individual labor contracts. It's specified in individual labor contracts. Considering, according to labor code, the salary is confidential. The agency is not entitled to communicate that information without the consent of each staff member. Another answer of the agency, another reply from the Agency for Public Procurement. So the Agency for Public Procurement informed us that our request of information regarding the salary revenues contain personal data, and provision of that data without consent of each person would contradict the provisions of the law on protection of personal data. At the same time, they informed us that each subject of declaration has the obligation to annually submit a declaration of revenues and interests to the National Integrity Agency, and that information can be accessed, can be open on the portal of that agency, of that institution. Here, there are two replies from the President's office, offering a complete list of persons, so management functions, with salaries, with supplementary salaries or bonuses, based on the system on the salary system. Here you see the reply from Orhei District Council. They provide information in a table. We have also replies regarding information requested on annual procurement plans and reports on public procurements. Here is the response answer from the National Agency for Archives, which suggested that all the information can be accessed on a web page of the institution. Similarly, National Institution for Social Insurance Agency also made reference to their webpage where they stated that all information is available. Hereby, we can make a comparison the answer from the District Council Stefan Bode and State Enterprise State Road Administration, which provided all the information exactly as requested: date, when the contract was signed, who is the contractor, what is the object of procurement, what is the amount, value of the contract. What regards subsidies, grants, and donations provided to legal entities, we have replies from Agency for Payments in Agriculture, Intervention in Payments in Agriculture, which informed us that all information about subsidies, grants, and donations, all that information is published including the legal basis, so that all that information is published on the list under list of beneficiaries on their web page. Another reply from the Ministry of Culture. Ministry of Culture informed us that subsidies are allocated. The subsidies that were allocated are provided in the law, budget law for the year 2022, and it is reported quarterly according to an order of the Ministry of Finance. They requested us to indicate what was the reason of requesting this information and to explain more clearly the data that were requested. Here is the reply of the Ministry of Labor, which informed us that the information that we requested for 2021 is available on the webpage, and information that we have requested for year 2022 for half a year will be published starting with 1st of February. So for us to wait till 1st of February, suggested us to wait till 1st of February. Here is exhaustive answers from Inspection for National Probation Inspectorate, Ministry of Education and Research, and Ministry of Infrastructure and Regional Development. There's exhaustive information that was provided exactly as requested. I will refer to some arguments. Now I refer to some arguments. These bizarre arguments for refusal to provide information. I selected only several institutions. In this respect, I'll try to be more concise. Answer from the Parliament of the Republic of Moldova. There are two answers. First answer is from July 2021, and second reply is from this year. You will see that the answers are practically identical, and there is the impression that some authorities prepare some templates, and then they use those templates for their answers. Here's the response from Ministry of Defense, which requested for us to indicate the purpose, specific purpose for requesting that information. Legal framework to ground our request, also to offer guarantees, to provide guarantees to ensure security of regime for safety and security of processing personal data, and to offer the possibility to depersonalize the data after the detailed analysis, saying that they cannot provide us, saying that they cannot disclose all that information that we have requested. Here there is this reply from Moldsilva Agency, Forestry Agency. So they qualified our request of information as a petition, and they provided us they provided 7 days to remedy, from their point of view, the deficiencies regarding the purpose for requesting the information. So we have a response answer from the Anti-Doping Agency and the Ednis District Council. The agency informed us that the staff of the agency have their salaries established according to the law, and the Ednis District Council requested us to present the statute of our association for them to be convinced that we are entitled to request information of public interest. And response or answer of the Ministry of Finance, which is the last one I wanted to comment, where they make reference to their response from last year, where they already have expressed their position. Last year, we requested information about the salaries, so salary revenues for the year 2020, and this year we requested information for the year 2021. Last year we requested information for the year 2020. This year we request information for 2021. Thank you. Thank you very much. Well, this was just a short presentation for you to understand how comprehensive, how complex was this research. Reports have already been published in 3 languages, and I encourage you to view them, to see those reports, and also to read the conclusions of the reports. I'd like to ask Vasily Lopnarov
să ne pună întrebarea.
if he had a question to ask.
Microfon, vă rog. Nu?
Well, I just wanted to refer to the list of recommendations. There was a list of recommendations to mention. I'd like just to mention, well, not to have so those answers, those bizarre answers. Just refer to Vasily Spinei, who is a pioneer of this legislation, access info. I did a search on the internet and he published information how the law was applied. He was one of the authors together with one of the authors it's very optimistic to solve the case with the Constitutional Council in 2 years maybe. So he was very optimistic then. So yeah, just I had a question for David. Have you heard? You probably heard that the first session there was an allusion to the fact that servants wouldn't want to provide information to anyone. If they know from the very beginning, if that information gets into the hands of the Trolls faction or not to, I don't know, Samorskaya Pravda, which has also a reputation to distort. Do you think this is sufficient reason for the supply information knows beforehand information from falsifiers of journalists distort all that information or abuse that information? Isn't this sufficient reason to refuse providing the information without packaging it in the way as Stella described?
I'm not fully sure if I fully understood the whole question, but
so the question was if the concern that was exposed, voiced in the first session, that the information would be misused by malign forces, is that a reason not to be fully transparent? Or how would you respond to that?
Yes, now it's all clear. So from the perspective of Tromsø Convention, from the perspective of, let's say, international standards, national security or protection, national defense, national security, in general, could be a legitimate ground for restriction of access to information, but it doesn't mean that any information relating to national security is automatically subject to restrictions, should not be released. The public authorities have to prove, it's not a job of the requester, of the journalist, of applicant to prove that this would not harm the release of information would not harm national security. It's opposite. It's a role of public authority to prove that release of information would constitute imminent serious damage to national security. So, of course, in principle, national security is a value that has to be somehow reconciliated with right of access to information, but it cannot be excessively used as an excuse not to share information, and the burden of proof is always on public authority. It's not sufficient to say that you will misuse this information, or this information will harm national security, release of information. It is necessary to prove how this damage will be done what kind of result, what kind of
David, sorry, if Charlie Hebdo ask you some information about salary, you offer them or not? Not security.
about what?
Charlie Hebdo
Yeah, but about what?
ask you about the salary of ministry. You offer this information or not?
My interpretation is clear. This is not an issue this is not an information that its release would create any damage to national security. It's not at all a risk. I don't see any risk to national security. And if I'm judge reviewing refusal of public authority to provide such information, for me it would be clear to say that it was illegal refusal. So, but of course I can imagine that there is some document, some information that could be kept in secrecy because of the seriously damaging effect of its release to national security, but not in this case. This is for me very clear case where information should be not only released upon request, it should be published proactively by public institution on its website and through other means.
Thank you. Mulțumim pentru răspuns. Eu aș vrea acum să...
Thank you for the answer. And now
Mersi. La un moment dat mi-a dispărut vocea în microfon, am în vedere, dar...
so that's like technical problem with the microphone. Now I would like to ask Luba Shevchuk to tell us, because we were discussing during the break about the new problems of access to information, to exemplify, to give some examples of this report, which is really exhaustive and from a methodological point of view, and questions that were asked and websites that were reviewed. So this media project, Cusens, what is it doing? How is it working? And what impediments is it encountering? Good afternoon. Part of the issues that we confront at you, but many of them are the same that we had in previous years. Maybe I'll repeat some of the things that I mentioned in the morning, but speaking of access to information, responses to requests of information, my conclusion is that unfortunately there are so many institutions that avoid to answer, or they do not reply to our requests, or they give incomplete replies, or they invoke right protecting personal data and so on. So we decided to go to court. Now we are in court with the Ministry of Health. We requested from Ministry of Health information about how much money was spent during the pandemics for information campaigns. COVID-19 information campaigns. We requested that information in January 2022 and in May. All that during it, we repeated our requests, and seeing that we did not receive, there is no result, in May, Ministry of Health report. So now there is a process, there is a court process. And often when investigations were often sued by those who are referred to in the investigations, for a media institution, court cases take time, money, we need lawyers to deal with those processes in court. Speaking of databases, I'll read what I was saying in the morning. Fortunately, on certain aspects, there's worsening of the situation, particularly physical access to the to the building of the agency of public services, respectively to open files of companies or NGOs. Although we have to pay for such services, and of course it's quite expensive, we do not get access to those files as it happened previous years when there were other governments. Other governments, when we were calling actually those governments as captured state in the past. Last experience with the Agency of Public Services was 2 weeks ago. We went there and we did not receive the services that we requested. We had to make pressure, we had to quarrel with them. We came to a point for them to return us the money if they're not providing the services. Believe that we as a profession are quite consolidated, but on some segments maybe we have to be even more united, more consolidated, and to treat all politicians the same and not to and when there are violations, when the access to information is not provided, we need to make public appeals, and in order for us to defend this right. So this government, to compare it with other governments, this government promised quite a lot, openness and transparency, and our expectations are somehow very high. And when those expectations are not fulfilled, the deception is also quite high. Marina Kozonat, Center for Journalist Investigations, she felt actually that we'd like her to talk, to speak about this, about the guidelines. There was a statement of the Center for Journalist Investigations. There was a program that was surprised how it was compiled. So guidelines, offering access to information in the most conservative way, the most restrictive examples were given. Please, can you please talk about this topic? So the issue, the problem of access, the issue of protection of personal data is a big impediment for us, and things have not changed for a number of years. Recently, we have discovered on the webpage of Center for Protection of Personal Data the guidelines on access to information based on legislation on personal data. And in those guidelines, there were a list of restrictions for journalists. There was some explanation how should we request information from public institutions in order to protect personal data or not to affect personal data. And that meant that we should give very clear arguments for the request that we made, to give reasons why we request information, to give arguments, reasoning what we will do with that information. All those requests we made in writing. So a lot of argumentation, a lot of reasoning that we need to provide based on those guidelines that the Agency of Protection of Personal Data prescribed. So they are trying to impede even more the journalists to access information, public information. Although in the law on protection of personal data, there is Article 10, which is quite confusing. It's somehow somewhat confusing, but its message is clear. Protection of personal data does not refer to requests from journalists. If there are requests from journalists, it should be clear that information should be provided. And this is not difficult. This is not hard. It is good. It is good that it is good that there is a plan to change the legislation, to change the law on access to information. So, first report was in 2007, actually, on this topic, on access to information. Center for Journalist Investigation was one of the first organizations that went to court, and I actually wish success to our colleagues from defense. We actually have abandoned for some time, abandoned our fight in court with the state institutions because it takes too much time. Because after 2-3 years of court cases, we were For example, after 3 years, we were winning the case in court, and they provided us the information that was relevant 3 years ago. And we did not manage to punish any person that they were not providing information. None of the case, none of the court processes, so we did not manage to any of the public servants. So no public servants were punished. So they should be responsible in case they fail to respect the law and public information. And the new legislation should take into consideration also this aspect. Because if there is no punishment, well, I'm not an adept of punishments, but otherwise will not educate public servants to respect law, because it is law on access to information. Regarding databases, as my colleagues have mentioned, we continue to pay. We continue to have barriers of access to information. It became more difficult, the procedure for access to information, that is the Agency of Public Services. So previously there were different institutions, now it's concentrated in the Agency of Public Services. Previously some institutions were more accessible. Now the Agency of Public Services, they expressed number of times openness. So management institution showed openness. I will give an example. I'll give you an example, which is, well, quite a significant case for us. So access of data, because we accessed some data for a journalistic investigation several years ago. We verified that information, the cadastre properties of a prosecutor who was now dismissed based on a corruption case, which was initiated based on our investigation, our journalistic investigation. But before performing that journalistic investigation, we had a lot of problems, because journalists are verifying the information when they start the journalistic investigation, and we verified that information. We had a contract with Cadastre agency. We verified the information, the properties of former wife of that prosecutor, with whom they apparently were divorced, and they were divorced. So they were divorced with that. And there was a complaint to the Center for Protection of Personal Data. There were a lot of letters from the Center for Protection of Personal Data. We were made to give explanations. The staff of the Center for Protection of Personal Data did not understand why didn't we publish that investigation. After verifying data, they asked why didn't you publish the investigation? And we explained we are documenting ourselves first. We are verifying the data. We explained to them that it could happen that we would not publish it before. So it does not mean that if we're requesting advice and information, this does not mean that we're going to publish it, because we have to check the information first. See, maybe you need to verify in databases, for example, and the center considered that we violated law because we did not publish the journalistic investigation. After that investigation was published, we had other problems related to protection of personal data. The criminal case was initiated against us. We were taken to court. And for the simple fact that we verified some data at the cadastre, we got a lot of problems. And it is a problem for investigation journalists, because the Center for Protection of Personal Data do not understand what is the journalist, what a journalist doing. They don't understand that journalists need first to document, to verify data, verify information, databases, and so on. And this is a problem. You can see, and you'll see. So the Center for Protection of Personal Data, when they developed those guidelines, they did not consult any of the journalists. They believe they know best the principles for protection of personal data, which are important indeed, but that protection of personal data should not violate other freedoms and the rights of journalists. So when there will be public discussions on the law on access to information, life. So it is important for journalists to be consulted and to examine various situations that we confront with in our work. For those situations, we take into consideration when the law is modified so that that law to correspond to expectations, our expectations that journalists have. Now it is probably the first case at European Court of Human Rights on access to information. There is the first case examined by the European Court of Human Rights, and the case has been already communicated to the government of Moldova. Thank you, Cornelia. I have a message from Olesa who's saying that there is a person who'd like to intervene. How technically could that person intervene? Online, if not. So it is a comment actually. A comment that received on the Zoom platform. It is a comment from Daniel Voda from Ministry of Foreign Affairs, who is suggesting that adjusting the methodology for communication directly with, so organizing some interviews for completing the methodology for evaluation. Stella, what do you think about the suggestion? We discussed with Daniel during the break. It is a very good suggestion. So he was referring to websites of the institutions as we have selected the information that we have selected to analyze and evaluate. Some of the information was provided in different format or different form. Maybe that information is less obvious or more difficult to identify. So search engines not always show all that information, and that information indeed maybe some information was not shown or was not identified on web pages. Maybe because the search did not show it. So indeed, the suggestion was to have an interview with the institution that is being monitored eventually to have an interview in the process of this evaluation. Regarding the new practices will be reflected. Thank you for the question. Indeed, the Ministry of Justice, so the new law. The Ministry of Justice, a consultative working group was created that is currently working on adjusting, developing of a new law, updated law on access to information. Sure, our suggestions from that group, myself, working with the Ministry of Justice, and we participated, either myself or Stella participated and reiterated the amendments that worked on and that were presented to Parliament to the Parliament, defining personal data of public interest that has to be defined, so information that has to be provided to journalists. How media should have access to personal data of public interest, so all that should be described in the law. One important aspect of the law is, as it was developed by the Ministry of Justice, it is almost ready, and what they have planned until so they planned that until 1st of December for that law to be presented for public consultations. Do not know what will be the way how this draft will be how the public consultation of that draft will take place. So either they will be just placed on the web page, or they will be certain events for public consultation. So certainly we would like for certain wide event to be organized to include all stakeholders, including National Center for Protection of Personal Data. We were all surprised to see that there are such guidelines. And the most serious fact is that that center is distributing those guidelines directly to authorities, and they are providing trainings to authorities how those provisions should be should be implemented restrictively. So the Center for Protection of Personal Data is organizing trainings for public institutions how to apply restrictive legislation. So there was an event with the Secretariat of the Parliament. So people who are behind that enormous amount of work that takes place in the Parliament. So the Secretariat of the Parliament, we had a meeting. We had a meeting with the Secretariat of the Parliament, and they said that they apply the law as it is, and they saw those, and they said that for them it's difficult to interpret the law in one way or another, because the law says what can be done, what cannot be done, right? On what information can be provided. Indeed, there is a problem. There is the issue that the legislation currently is deficient, and the law, as I was saying, the law has to be very clear and not interpretable in such a way that it would be applied respectively. We will insist and on and the draft law will go to Parliament with including all requests, all the needs of the press. That's how we wish the draft law reach the Parliament. So I'd like to ask Mariana Radza, what is her experience working with public institutions, and if this report is describing the situation. Actually. So, well, it was not planned for me to speak during this panel. There were some representative authorities had to participate. I was thinking, why things have not improved? Why isn't there more transparency, more communication, more satisfied journalists? Because this does not require more budget, does not require additional budget. Why isn't it happening for journalists to get more access to information? I want to believe, and I really believe that authorities wish for journalists to have more access to information. But unfortunately, many years in a row, practice showed that every time it is a priority, first priority, say so, for those who are in opposition. And immediately when they get to power, it's not a priority anymore. It is a problem that has to be solved, but maybe a little bit later. So this is an issue. When the government has changed last year, I was talking to representatives of the current government, and I told them, either you will make changes to give more access to information to journalists the first half of the year of your mandate, or you'll not do it at all. I don't want to believe that the changes will not be made. I don't believe that changes will be done. But I heard today and on other occasions, I heard more excuses, and they spoke about the barriers, impediments they encounter, to whom we should provide information, what kind of signatures we need to provide, stamps, digital signatures, for the journalists go through all those parts or to go through all those procedures. The fact that in this panel there are no officials present, this is an indicator that offering healthy access to information to journalists currently does not represent a priority for the government. If I'm wrong, please prove no. If the officials want to listen to us. Unfortunately, I encounter the same problems as the colleagues who spoke earlier. And I foresee at least several dangers next year that could worsen this index for the year 2023. One of the dangers, Cornelia mentioned it, Pandora's box opens as there are cases against journalists who access personal data in public registers. Currently, there are we're informed that we're taking to court. They're taking to court those cases and requesting why, for what reasons, and for what purpose we have obtained or requested information about personal data about them, about their relatives who are not of public servants. So journalists do not have. Most often we know approximately where the properties of certain public servants are. And we often have to search in the vicinity. Until you find the house of a dignitary, you have to access at least other 30 cadastral numbers of some persons who are not public, who are not of public interest. It's information that we do not use. We do not use, but we leave traces that we requested that we have access to that information. Any of those persons can take us to court. Luckily, this does not happen, but this is that matter of time and luck. So it is self-censorship that you are afraid that you can be sued for accessing. I hope that Agency for Public Services will renounce or will give up imposing the rule that we would have to inform all the persons whose data we're going to access, to inform them about that we're accessing their information and informing them for the reason why. And that if there will be such a requirement, we will not access personal data anymore, because this is a very great danger for us, and we'll have to employ additional staff. We'll have to write letters to all those persons. Another trap for us. And from my point of view, it is an abuse. This digital signature that is requested on requests for information that we send. And it's not about only one institution, it's not about only about now. So electronic signatures, these were usual explanations, for example, from mayor's offices. For example, they're saying that they are not processing our request for information because there is no digital signature. According to the law on access to information, this is not specified. So we are treated from the point of view of law on petitions, and this is the main track. So we decided not to accept such conditions that are imposed. Our institutions, we decided not to impose, not to follow those just because we do not agree that our requests for information are treated as petitions. So meaning that they have to reply 30 working days, twice as much time as the time that I have to answer the journalists. I believe that this is an abuse. We are treated from the point of view not the law that is relevant for us. And it is unfortunate that those who communicate further to the authorities are not present in this discussion to explain to us why it happens this way, and to find solutions to correct the situation. I was saying from the beginning that the authorities and politicians are well-intentioned, because there's a big discrepancy between the way how we receive responses to our official requests and how we communicate with them directly. So for us, it is not a problem for us to call the minister and to get their answer on the phone or in front of the camera. I don't see a problem with that. So they are quite open. At the same time, when the information is requested in writing, authorities at all times always had a problem to offer not opinions but official information. So they had a problem to offer official information, and this is a paradox. government can do all necessary cleaning inside without and why no government wants this or non-institution.
Avem o intervenție, Olesia,
There is an intervention online intervention.
e posibil tehnic, am întrebat mai devreme și a spus că da. Am promis
For the
după
person to
Mariana
intervene, so I
să dăm
promised
rezultatele
after Mariana for the person to connect.
și după aceea revenim, Cornelia.
After that,
Daniel.
we'll continue.
Surprise,
Okay,
surprise.
Daniel.
Oamenii care comunică pe viu, comunică și
So
online.
persons who communicate live, they communicate also online.
Da,
Nu se aude sunetul, vă rog. Daniel, mai ești puțin.
У меня что-то случилось. У меня это случилось. Я чуть-чуть
Nu cred că așa e, Daniel ar vorbi, dar e posibil să ne conectăm?
So checking if it is possible to connect the sound.
Dacă inginerii dau din cap,
So it seems that it's not possible to hear the sound. So asking Daniel to ask a question or to write in the chat. Write in the chat, and this will be.
Da, eu vreau
nice.
să fac o
Yeah, please, Cornelia. I just wanted to make clarification of what Marianne was saying, or to add to what Marianne was saying. And my suggestion to have have some provisions for journalists to work. The law on access to information is the law of all citizens. It's not the law just for journalists, because all people should have access to public information. But because the specifics of our work is that we have to request information, to request daily information which we need to check, it is necessary to have some provisions for the information for journalists' work. Particularly referring to the databases such as Cadastre. Our access to Cadastre database are visible. So the staff from Cadastre has the opportunity to see what information we access. This is risky for us because when we try to check some information related to acts of corruption, some persons that are related to it's suspect that they are involved in corruption and checking the information of their relatives, and this information being visible for the staff of the Cadastre is a risk for us journalists. And we discussed this previously with the Center for Protection of Personal Data when they were trying to find solutions for us journalists for access to various databases. And there is space for discussion. And what Mr. Botnaro was saying, there are institutions that are considered media institutions, but they're actually propaganda institutions which could indeed use that information for other purposes than for real journalism. So there is so the possibility to see for the new law and for us to analyze and to make a law that would be good and not to have a law that will not create barriers and will be give the possibility for journalists to do their job. So, as a conclusion, do you see any do you have any optimism? Do you expect positive, good changes? It's a complicated question. Well, speaking of the Agency for Electronic Governance, I do see some improvement and some openness for access to certain databases where we can access information which we could not access previously. But speaking of Agency for Public Services, the blockage that we have with 2 registers, we have meetings, we have discussions, online, offline meetings with them since summer, but things don't change. I heard answers today. I don't have too much optimism in that respect. But I would wish as a journalist for this issue to be solved as soon as possible. I also remind Tatiana that hoping new package of laws, hoping and the new law on access to information, we do hope that this will improve the situation. If there are any questions in the room, because we're practically coming to the end of this session. So I have a small comment and also a question at the end of this session. I do journalistic investigations, and I'll give you an example. I agree with the authors of this report that legislation on access to information is obsolete. Last year, I requested information. I submitted a request for information to find out if a candidate for member of parliament for the local parliament in Gagauzia. So to find out if that candidate had criminal records or not. So and I decided to ask both from the local prosecution office and the general prosecutor's office, and I received the answer from local prosecutor's office from Gagauzia, and they said that they refused to provide information saying that would affect the reputation of the person. So they said that would violate the reputation of the person, while the general prosecutor provided the answer indicating that that person indeed has criminal record, has a criminal file on fraud, which was not by that time closed. So now thinking of those public servants who are disciplined and who are providing all the information requested, and thinking also of those public servants. Recently, I had very good experience with the Soroka District Council. I asked them a million questions, and they provided even documents that they didn't ask for. And in their willingness to show transparency, because they wrote at the end of their reply that they want to be as transparent as possible. I would like to appreciate really the authorities who are providing all the. I would like to ask David, who's this report, and I know, as far as I know, you are from Poland. To see these barriers in providing information here in Moldova, particularly that protection of personal data is involved. After GDPR entered into force in the EU, did you hear similar complaints from journalists from your country or from other EU member countries?
David, the ball is in your court.
Thank you very much for this question. It was exactly the topic I hoped to raise at the end of our discussion. So GDPR, adoption of GDPR provoked some discussions about what is the relation between those new standards of protection of personal data and right to information. And this was also analyzed by Court of Justice of European Union. It was discussed among experts dealing with both areas. And in our case, in case of Poland, which is the case of also other countries, there were also some landmark judgments of courts that basically resolved this issue. So, for example, we had authorities that refused disclosure of salary information, referring to GDPR. So stating that if you request this information using law on public information, but you do not specify the special interest in obtaining data. So if you do not let's say, meet all the conditions established by GDPR, then you should be refused access to information. And then the courts, because this is already quite established case law, the courts decided that adoption of GDPR does not undermine, does not hinder application of the law on access to information. So if the law on access to information, which is in our case, says that information about persons performing public functions are subject to disclosure, if this law states like this, it prevails over the legislation on personal data protection. So this kind of, in our case, it was clarified that, for example, salary data are subject to disclosure, and GDPR does not change anything. I mean, GDPR does not undermine transparency legislation, and GDPR cannot be used as an excuse to refuse access to information about people who are public officials, who are performing public functions. GDPR does not restrict access to information about these persons and does not introduce any restrictions in this matter. A law on access to information fully applies. You don't have to justify if you request data. You don't have to prove any special interest. You have this, as every citizen, you have access to this information unrestricted.
Mersi mult, Cornelia vrea să zică despre experiența ei cu datele unor companii.
Thank you very much. I'd like to mention our experience with some companies. GDPR actually raises some other problems to journalists. So we already had a number of requests to Romania from representatives of various companies and persons who are actually invoking GDPR. They request that data journalist investigation to be deleted. And we responded to them that there are schemes of corruption, and we're not going to delete any names, and including persons from the entourage of you requested to official requests referring to European legislation, indicating that their names have to be deleted from the journalistic investigation. We answered, and things stopped at that point. We have five such requests. We were not too concerned, but nevertheless, we want to discuss and see what should be our action. Suspect. If you can address Tatiana to Venture Center team, have a comment online. The National Bank of Moldova appreciates this report. They are slightly surprised with the results on their institution, a message from Elena Moldovan, and they said that they would like to understand better what they need to do better, how should they improve the situation in case of the institution. So our suggestion is for them to address to the authors of this report. So suggestion is to make the feedback directly via email, both authors and organizers. We'll be happy to, be open to meet because we want more transparency, to ensure more transparency. Stella is also author of this report, so I'd like to ask Stella now if she can make it top three, which are the best institutions, which are the worst. Top three, okay. Top three is sufficient. Particularly, I'm interested if where is the justice system, among the first ones or among the or lagging behind? Because we're an example that in the West, case by President Obama. But we leaders of newspapers, or Mariana Rața, well, maybe because of lack of information, but the view is of maybe they want that they will need to have access. Okay. Well, the question is about chicken and egg. What came first? So it's not about Mariana Rața. So, which are the first three, top three, and the last three? So, Minister of Economy, Minister of Infrastructure, Regional Development, and Competition Council. So 3. And Ministry of Internal Affairs here. Actually, this list, the entire list we see now on the screen, they did not provide information. So this list is available in the report. Thank you all for your patience because we are already late for the coffee. I hope so we go to the coffee break and then we continue. Good luck. So just some conclusions. Just 1 minute. Thank you all for had the patience because this is a comprehensive report, and as the authors have mentioned, you can find this report online. 3 languages. Thank all participants. Participants present here and all participants who are online on Zoom platform. There are more than 70 public institutions that are following us. Over 70 institutions that are following us, and we hope that our recommendations are clear and that refusals should not be tolerated anymore. As should be ensured. And as I mentioned from the beginning, this event is part of Forum Media Forum 2022, organized with joint support of Soros Foundation, USAID, British Embassy, Project Press, and Support Democracy, Media and Freedom House, Center for Independent Journalism, Economic Foundation for Southeast Europe, Academy, Germany. Thank you and good luck. And wish you follow the next panel. Now, coffee break. Half an hour. After which, you'll see that there are 3 workshops. 3